Good afternoon, friends. Again, before you with folded hands to discuss one of the leading case of the advocate on record, the examination of Supreme Court of India. Friends, a different type of case is this. Please listen attentively. There are two parties who made contract with each other. Both are foreign parties. One party is Technip SA, that is of France, and second party is SMS AG, that, that is of Germany. They made contract with each other, but the project about which dispute arose, they have to construct in India. The projects belong to India. Parties are both foreign parties, and when the dispute arose, they settled themselves through arbitration as was clause therein, and the arbitration was held in Paris, France. So the question arose, one party is of France, second party is of Germany, works on in India. Can this arbitration award be challenged in the in India on the plea that this award is against the public policy of India? This is the case. So I am diving deeply into this. Please listen attentively. What the issue is, how the Indian court ruled for that. The case of Technip SA and versus SMS AG is a significant legal dispute related to the enforcement of foreign arbitration award in India. It primarily deals with the issue is whether an award passed by an arbitral tribunal outside India can be contested on the ground of public policy under Indian law, even if the award was rendered in a foreign country. This is the issue. Going to the facts of the case, the dispute arose from a contract between Technip SA, a company based in France, and SMS AG, a company based in Germany. And the dispute which arose, the contract were related to projects in India. And the parties had agreed to resolve their dispute through arbitration in Paris, that is in France. The arbitration tribunal issued an award in favor of Tech SA, which was challenged by SMS AG in India under Section 34 of the Arbitration and Conciliation Act 1996. SMS AG sought to set aside the arbitral award by arguing that it was against Indian public policy, which is one of the grounds for refusing enforcement of foreign arbitral award under Section 48 of the Arbitration and Conciliation Act 1996. So the key issues were whether a foreign arbitral award can be set aside or refused enforcement in India if it is found to be against Indian public policy. Second issue was the scope and meaning of public policy under Indian law in the context of international arbitration. So these key issues were to be decided by the Honorable Supreme Court. What our Honorable Court said, what is the ruling? The Honorable Supreme Court of India, in its judgment, addressed the question of whether foreign arbitration award could be challenged on the ground of public policy. The court held that foreign arbitral awards could be refused enforcement in India only on limited grounds under Section 48 of the Arbitration and Conciliation Act 1996. What are those grounds which are covered under Section 48 of the Arbitration and Conciliation Act? First one is the award being in conflict with the public policy of India. Second is the award being in breach of principles of natural justice. Third one is the award being based on corruption or fraud. So the court emphasized that public policy should be interpreted in a narrow sense. When international awards are concerned, in its implication is concerned in India, then they should be, public policy should be interpreted in a narrow sense, in line with international arbitration standards to avoid undermining the principles of comity of nations and enforcement of international commercial agreements. So they said keeping with these factors, it should be narrowly interpreted. Now, what key points after this judgment was announced? Firstly, it said, as I already discussed, it said the narrow interpretation of public policy. The court ruled that the concept of public policy in the context of enforcing foreign arbitral award should be construed narrowly. The court stressed that foreign arbitral awards should be enforced unless they are patently illegal or contrary to the most fundamental notions of justice in India. Second one, the limited grounds for refusal. It was clarified that foreign arbitral award could be set aside only on specific grounds such as lack of jurisdiction, failure to comply with the rules of natural justice, or violation of public policy. Violation of public policy, and earlier the court said that even though violation of public policy, but it should be construed narrowly, not broadly covering everything that it is coming under the violation of public policy. Then promotion of international arbitration. We should, while giving judgment, we should keep in mind that we have to promote international arbitration. The judgment reinforced India's commitment to upholding international arbitration agreements and ensuring that arbitral awards are not easily challenged, thereby fostering a more favorable environment for international commercial arbitration in India. So this was such a liberal judgment. It might be having impact of the case. So impact of the case is the case strengthened India's position in the international arbitration landscape by promoting the principles of minimum intervention by courts in the arbitration process. It reaffirmed India's commitment to honoring foreign arbitral award, which is essential for encouraging international trade and investment. This decision also aligns with India's obligation under the New York Convention on the recognition and enforcement of foreign arbitral awards, to which India is signatory, and it sets a precedent for how foreign awards should be treated under Indian laws. This is all about, friends, about this topic. I will be again before you with folded hands for next topic. Please wait for that. Enjoy your life. Have a great day. God bless you all. Thank you for watching.